Hello, everyone, and welcome back to Face the Fear podcast. We're doing another virtual podcast, which just seems like it goes along with the times that we're in today. I'm sure many of you live on Zoom and WebEx now, so this should be no surprise that this is how we're conducting podcasts now. But Nicole and I are so excited to jump back in. We've taken a little bit of a break in the last few months just for time to spend with family and some personal things. But we have an amazing guest with us today. Kelly is an attorney up in Milwaukee, Wisconsin, and she is going to dive into more detail on estate planning, which we've covered a bit in the past if you've heard our episode with Matt Erpelding, but this topic is so broad and there's so much to learn. So we're really excited to hear Kelly's perspective and just glean a little bit more of her knowledge and insight on the topic. So thank you, Kelly, for being here with us. And if you don't mind, just giving us a little bit of introduction into yourself and what inspired you to become an attorney and focus on estate planning?
Absolutely. Well, I'm very excited to be here. So thank you for having me. A little background on myself. I am originally from Indianapolis and went to St. Mary's College and then continued to go farther north for some reason up to Milwaukee and got my law degree from Marquette University. I always was interested in the legal field. I just didn't quite know what form that would take. And then when I was in college, I was a political science and economics major. And inevitably, the conversation about law school comes up and ended up taking kind of a law and econ class, which really piqued my interest. So decided to go to law school at Marquette. I knew I wasn't going to be a litigator. I wasn't interested in being in a courtroom. And so estate planning was kind of a natural transactional practice for me to explore. My interest is kind of twofold. One, I have had some family situations where probably some estate planning would have made sense. And so I really had a close relationship with some family members that led me to say, hey, maybe this is something I need to look into. And then I am a natural planner. So ever since I was little, I had my planner out, taking notes, making lists. And so it was very natural that I would not only plan for myself and then plan for other people as well. So I think the combination of just that experience and then also my personality, it's kind of a natural fit for me to get into estate planning.
That is awesome. Thank you so much for sharing a little bit more about your background. And we were introduced to you through Mike McLaughlin, who is my personal boss at Ash Brokerage. And he met you and just thought, you know what, I think she, being just a younger woman in the field, would be a great fit for Face the Fear to talk a little bit more about why this is so important for, everyone, regardless of age, but millennials as well, and not only planning for themselves and their families, but also helping their parents and grandparents have those planning conversations as well. So really excited to dive into that topic with you.
Absolutely.
So from your personal experience, what are some of the big myths out there around estate planning as a whole?
I think one of the biggest myths is estate planning is only for people who have a lot of money. It's only for the rich people. And that is absolutely a huge hurdle that we have to overcome when we talk to people generally about estate planning, because it's so much more than planning for estate taxes. Estate planning is for everyone who is a legal adult, which is 18 or over. So this is not for people who have a lot of money and are setting up complex plans. It is for them too, but everyone needs an estate plan, and a lot of people don't feel like that's necessary for them. So the first hurdle is just convincing everyone that they need to get this done.
That is huge. I mean, I never would have thought until we got in the financial services industry that I would have to think about estate planning until either I was old or I had a lot of money.
Same.
Correct. And a lot of people don't realize when your child turns 18, they are legal adults. And so despite the fact that they're going to college or might be starting their first job and probably still somewhat dependent on parents, legally, parents have no rights to any information or to make any decision for their kids. So our initial conversations about estate planning start with kids going to college, starting their first job. What documents do they need in place to protect themselves? Even though they don't have a lot of assets, they still are adults and need at least powers of attorney and HIPAA waivers.
Nicole, you want to jump in with the next question?
Yeah. So what if somebody passes away and they don't have any estate plan established? Does it depend on the state or as a whole, just for anybody? I mean, how does it work?
So even if you haven't put together wills, trusts, powers of attorney, you do have an estate plan because depending on how assets are titled or if there's beneficiary designations, they're going to pass according to some of those rules. If you own assets individually, so no joint ownership, and there's no beneficiary designations, you're going to have to go through probate to deal with those assets. The probate statutes will say who your heirs are based on what you have and your family makeup. So the problem with that is sometimes you might end up leaving assets to people you didn't intend to and maybe not in the best structure based on their situation. So the intestacy statutes differ a little from state to state, but they're basically going to find your next living relative, which may or may not be what you intended.
Yeah, very true. Can we kind of break down the word probate and kind of go into exactly what that means just for somebody that's starting out?
Sure. So probate is basically the court process of settling your affairs. Another common misconception is that if you have a will, you avoid probate. So a lot of people think, well, I got my estate planning done. I did a will, so I'm good. Wills go through probate. That's actually their sole purpose. So even if you have a will, those assets have to go through probate for that will to be followed. Essentially, it's the process of kind of consolidating all of your assets. There's paperwork that's filed with the court. A personal representative or an executor in some states is appointed, and they are tasked with following the terms of the will. One of the downsides of probate is that you're in the court system. And as you guys probably know, that's not the most efficient process to go through. It can take generally a year to a year and a half to get through that whole process. And that is all public knowledge. At least in Wisconsin, you can hop on a website and click a case and find all of the information regarding any filings. A lot of people don't want that information to be out there. There's fees and costs involved. You're generally going to have an attorney help you. And so it's not the most efficient way to leave assets if you're wanting to avoid probate.
Yeah, that definitely makes sense. Thanks for that.
So if a will is not going to help you avoid probate, what maybe are some other strategies that could help you avoid that whole long, lengthy process?
So what we talk to a lot of our clients about is setting up revocable trusts. Wills are a pretty common thing that people understand. They see it on TV. That's what people get in the movies. Really, revocable trusts are, for most people, the base estate planning document and have been for the last 20 to 30 years. There's a lot of benefits that revocable trusts offer, one of them being probate avoidance and a more efficient administration than a will. And so a lot of our clients are coordinating their assets with a revocable trust and having that serve as really a will substitute. So what happens when you pass is dictated by the trust. And then one of my other misconceptions is then that you have to actually fund your trust, which I know we're going to get to. But
So I'm curious to know if there's an easy resource or a way to find out what the rules might be in each state around what happens if you die without some sort of estate plan. Because I know you mentioned they do differ from state to state. So I know some people might be curious just figuring out, okay, well, what would happen? Where would my money or assets go if I died without an estate plan?
So it's usually statutorily set. So there's literally a statute that says if we're in probate and there's no documents that say where things go, this is who your next living relative is. So really you'd have to look kind of state by state at the statutes. Most states have some type of information, if you Google it, that you'd be able to find some of that.
I think that could really like shock people if they saw where it might go without.
And it also in blended family situations becomes even more of an issue because it might go to a surviving spouse, but if the surviving spouse is not a parent of all of the children of the decedent, then we get into issues with dividing it between them. And so complications can arise, which those issues are better dealt with within estate planning documents than leaving that to the statutes.
Does it also depend? I work with clients and, setting up the life insurance, that kind of thing. And I've looked up a couple states and I've noticed that if they leave or they name their child as their primary beneficiary, some of the states will actually step in and hold those funds until the child is of legal age. So that right there points to why you should always have something set in place, to avoid something like that, because the state could step in and hold those funds unless you're directing them exactly where they need to go, right?
Right. So I do a lot of probate administration, so I see kind of the pitfalls that come into play without proper planning. And minor beneficiaries is one of the biggest things that we need to plan for. If you don't plan for that in your documents, you're generally, not able to leave assets outright to minors. And so you're in situations where you're having guardianships or custodianships created to hold those documents until they reach an age of majority, which is going to differ from state to state. If all of that was contemplated under a revocable trust, that would be a much more efficient way of handling that. Right.
So when should somebody establish an estate plan? I know we talked about, as soon as possible. How often should it be revisited? And then what other forms should be revisited and how often, I'm thinking, for example, like a HIPAA form.
So we advise clients to pull out your documents every 3 to 5 years. If you're in a more dynamic time in your life, edge towards 3. If there's not as many changes, closer to 5. And by changes, I mean kind of trigger points to at least review your plan. Having a child, getting married, buying a house. On the flip side, getting divorced. If someone in your plan maybe passes away or becomes incapacitated, things like that are always good life events to reassess. But in general, 3 to 5 years is your goal to pull them out. That doesn't mean you'll have changes, but you at least want to be comfortable with who you've named to some of those fiduciary positions and also comfortable with how assets are passing to individuals. We want assets to go to the right people, but we also want it to be in a structure and a format that's appropriate for the beneficiary. And that's, again, one of the reasons that intestacy and probate are not always great, because you might have beneficiaries that require more thought and structure in terms of how they receive their inheritance.
I think, one of the biggest just reasons for estate planning, no matter how old or young you are, is the fact that family situations are always complicated. I don't think anybody has a family situation that is like, Leave It to Beaver style family where everybody's
some people think that they do.
They may think they do, and then maybe somebody passes away and then they realize that they actually really didn't. So just even with family dynamics, it's so important to avoid hardship, I think, later on when, you personally pass away or a relative passes away, and just the amount of grief that can potentially cause someone when it's left up to this kind of all powerful state that then dictates where funds go without any sort of understanding of emotional connections or relationships between family members.
It's really, from my perspective, a gift you can give your family. I know it's not fun to talk about. I get it. No one wants to talk about their eventual death, but it is going to happen to all of us. And your family's already going to be grieving you when you pass. To add any confusion or complexity or cause to fight over things just leads to more family issues when they're already in a state of grief. And so, in my experience, sometimes the relationships and the dynamics that come out after someone passes, depending on what they're fighting over and how they're trying to get through the administration, can really affect long-term those relationships to the point where they might not be fixable. And a lot of that stems from failure to plan or failure to communicate with your family about really what your wishes are and how you want things to go.
Do you often see younger people in your office? Or I guess when that does happen, was there a triggering event that led them there? I'm just curious to know, how many millennials are you really seeing walking through your door?
A fair amount, but I think that's probably because I am of a similar age group. And so we kind of like to work with each other, as I'm sure you guys see as well. But a lot of our clients rely on financial advisors, quite frankly, to help them understand the need for estate planning. And that's kudos to the financial advisors who are having these conversations with their clients. As I mentioned, estate planning isn't a really fun thing to talk about. And for a lot of people, while some are self-motivated, they need a little nudge to come and see us. And so whether that's because an advisor has communicated with them, or unfortunately they might have experienced a bad situation and want to make sure that their family doesn't go through that, that's really where we're seeing them come in. But also millennials are experiencing a lot of those life events that I just mentioned that I think are causing them to think about it too. So they're getting married, they're buying their first house, they're having kids, and they're realizing, hey, we need to put some stuff in place to make sure if something happens that the kids are taken care of, et cetera. So it is not just old people who are coming in to do estate planning. And I hope that that continues to be the case.
Absolutely. It's just a more of a matter of people talking about it too. It's starting that conversation, which is, Nicole and I's whole purpose with doing the podcast really is just to encourage people to think about things that you don't normally think about until something bad happens. And then at that point, it's really hard to fix anything at that point. So, having a conversation with girlfriends over like wine one weekend could lead you to creating an estate plan that could, hugely benefit your family going forward. So that's just
absolutely. And, planning on the front end is much more cost effective than trying to figure out on the back end if there isn't a plan done. So it's really in everyone's best interest to get this figured out before someone passes. It is much messier and much more expensive to have the fights and to figure out what happens after someone passes. There's no one there to say what they wanted anymore. And so that's really why we see a benefit to doing this sooner rather than later, and quite frankly, as soon as possible.
Mm-hmm.
So just a quick fun little story. My husband and I recently we used our resources we have available to us to create a will. Our company gives us the resource to do that. So we just recently set ours up. We've got some medical stuff coming up and we want to make sure that, it's all put in place. But it brought up some really interesting conversations about, what happens in the untimely passing of one of us. Like, how do we want that? Like, what do we want our funerals to look like? And man, that is a creepy conversation to have. But like, he had so many different thoughts that I had no idea about. And it's so worth it to have that conversation now versus later on down the road. Just, you never know.
And I think conversations are huge to estate planning because the documents can only encompass so much, right? Particularly the powers of attorney. And we talk about this with our clients with healthcare powers of attorney. Have those conversations with your agents about what your end of life wishes are, because they're not going to know if you don't tell them. And if that time would ever come, they don't want to be left trying to figure out, did you really want me to disconnect you or not? That's not something they want to be thinking about at that time. So the conversations with the family, the more transparent you can be, the more helpful it is when you do pass or even become incapacitated. And the same conversations can be had with children or other beneficiaries. When you plan in a vacuum, sometimes a lot of that communication doesn't happen. And then that leads to misunderstandings after you would pass away that maybe didn't need to occur if a family meeting or something like that was had.
I think that's a good point too, because sometimes there can be kind of the secrecy around estate planning, I think, of, no one really talks about what's in the will because they're afraid it's going to hurt feelings or something. But in reality, even though the conversations might be difficult, it could be a lot better to just sit down and have open conversations with people as you're doing the legal processes of writing a will and getting a trust set up, so that you're avoiding, again, more hurt later on down the road. And it may really actually lead people to be closer together because it forces them to get things out in the open that they've been uncomfortable talking about or didn't really feel like they had a segue or reason to bring up until, they're going through this formal process.
Right. Absolutely. And this is an opportunity you have now to kind of lay all of that out, and there won't be any confusion, particularly with siblings saying, well, mom said this and dad said this. So in my mind, the more communication, the better. Now, you don't have to say, your asset level and what you're getting. Some people do, some people don't. But at least having those conversations, I think, really helps with the family dynamics when someone passes then.
Do you think that it's a responsibility of, the financial planner to advise their client to have that conversation, to bring family in and to say, hey, maybe this is a good idea, or, is it on the person themselves to, I guess, just make that decision?
I think it's a case-by-case basis, and it's going to depend on what the client's most comfortable with, and probably from the financial advisor's perspective, what relationship they have with the client and maybe the children. We talk to our clients about it, but some say, no, I'd rather not. And some say that's a great idea. So it really depends, I think, on a lot of factors. From my perspective, if you don't want to have the conversation, at least we can put some stuff in writing that would clarify your intentions. But it's kind of a case-by-case basis. I think at least bringing it up is important.
Yeah, definitely. So we talked a little bit about powers of attorney. We kind of threw that term around. How can somebody, or how should somebody, choose who will be their power of attorney? And can it be changed over time? And how does that work?
So there's no right or wrong answer to that. Essentially, a power of attorney, just so we can back up and say, but that's a document that allows you to appoint someone to handle either your financial affairs or healthcare decisions at a point where you are incapacitated. There are some powers of attorney for finances that can be effective immediately. For most individuals, if they're married, they're naming their spouses. And then for successors, it's really going to depend on who you're comfortable with. So between the two documents, we might see different people named. If they have a child or a sibling or whoever it may be that has a financial background, maybe that's a good person to consider for the financial power of attorney. Same with healthcare. But at the end of the day, you just want it to be someone that you trust and that knows your wishes and that you're comfortable with. That can change over time. Both of those documents can be updated and should be updated at least a couple times during your lifetime. One, because your wishes might change, particularly with a healthcare power of attorney. Your thoughts on whether you want to be kept alive and how long for, if you are in a persistent vegetative state, could change. younger individuals might want that to happen for a longer period of time than older individuals. And then the people you name might change. So to update it, at least review it every 3 to 5 years is worth it. But both of those documents can be changed as long as you have the capacity to do so. And so that's really why it's important to review those more often, because those documents do allow someone to make some of those decisions.
I'm curious to know if there needs to be anything around selecting a power of attorney where they have like a family tie. I mean, can you pick anyone to be your power of attorney? There doesn't really need to be any sort of like family ties there, correct?
Correct. Anyone can be your power of attorney.
But I'm assuming they have to also sign off on documents to agree to be your power of attorney as well.
Yes. So you certainly want to talk to anyone you name. And, some people might not want to do it. It is a big responsibility. I do have, clients who say, well, I can't pick between my kids. And I always say, your kids might not want to do it. I mean, it's not something that I think a lot of people want to do, but do out of, kind of the love for the person that's naming them. But it's certainly open to anyone who they would appoint to serve in that position. I will say we do have, this is kind of another, I guess, myth I have, but a lot of people will say, well, I want to name multiple people to that role. My thought has always been you want to name one person and then name successors. There's just a lot of pitfalls to naming multiple people to a lot of these fiduciary positions that we talk about.
That just seems so messy to have more than one because people's emotions get pulled into it. And oh man, I can't imagine having more than one. That's so messy sounding.
It can be because we've had to deal with it and, getting 2 or 3 signatures on everything. And the biggest thing is if they disagree, right? Then you're in a position where you have people who need to work together and they're disagreeing on what they should be doing for mom or dad or whoever it is.
So we talked a little bit about like end of life decisions. How does someone go about researching what those different options are and making sure that they are the most informed that they can be before they decide, around life support or, staying on a vegetative state versus not? And I just feel like those are really important decisions, and there's not necessarily a ton of resources readily available out there. People don't talk about that. So anything you would recommend for someone to educate themselves about maybe pros and cons of different decisions around end of life?
I would suggest actually talking to their doctor. The doctors are the ones that are either activating the healthcare power of attorney. So if for a healthcare power of attorney to be activated, at least in Wisconsin, 2 doctors need to certify that you're incapacitated. And at that point, your agent will step in. And I'm pretty sure it's similar for most other states to have a standard similar to that. And so at that point, the agent is going to act. So the physician is really the one who's going to be making that call. And they're also going to be able to talk to what things like a persistent vegetative state means and how that is implemented. On the legal side, then talking to your attorney, we can talk about how this would work legally, but there's a whole medical side that I'm not trained in and I shouldn't be opining on when clients ask about, some of those questions. So I think between your doctor and an attorney, those conversations can be had that would lead you to be able to make an informed decision about that.
Great.
That's so interesting. I would never have thought to go to my doctor to have that conversation, but it makes complete sense. I would have never thought about that. Thank you for that.
So many different people to be pulled into the whole plan, because the financial advisor can add a lot of great insight, and then obviously the attorney is absolutely essential, the doctor, family members. It's a whole kind of process to get things in place, and you don't realize that I think until you really start digging into a conversation like what we're doing now. So great point.
It's really a collaborative effort. So what I do should not be done in a vacuum. We work with financial advisors, life insurance agents, kind of the whole realm of individuals, other family members, to put a plan in place. And the reason a plan works is because everyone is coordinating their efforts. When plans don't work, it's because documents were drafted and, for example, they were never transferred, the assets were never transferred to the trust, or there was miscommunication between the children and the parent. And so I think the more you can think of it as a collaborative effort, the better the plan will be.
And you talked about that a little bit earlier. What happens when sometimes trusts are set up and then not funded? Can you talk a little bit more about that?
Yeah, so there's really kind of two, I guess, phases to estate planning. The first one is setting up your documents. So signing your documents, drafting the trust, the will, the powers of attorney, all that goes into an estate plan. And then if you create a revocable trust, we have to have the assets go into the trust. And so we do that either by updating title to assets such as real estate, cars, things like that, or updating the beneficiary designations so that the beneficiary is the trust. We need to do that because if it's not in the trust or pointed towards the trust terms don't have any jurisdiction, I guess, over the assets. So if you have a trust, but you don't put anything in it, the trust can't do anything in terms of distributing those assets in accordance with what you put in that trust.
And how often does that happen where you do all the work to set it up and then it's just never funded?
It happens a lot. So I mentioned I do a lot of administrations, and we do have some trusts that are funded, but a lot of times not everything is in it. So maybe the house gets in it, but there's this other account that doesn't get in it. Ideally, everything gets in the trust, and then we only have to deal with that administration. But it's common after people sign documents to open new accounts or buy another house or sell a house. And in, kind of the everyday life, they forget that they need to update title, update beneficiary designations, whatever it may be. So when the trust is executed, typically a lot of clients are good about that, but the farther away they get from it and the assets that turn over or new assets appear, that's where sometimes that is forgotten. And that's why it's important to kind of take an inventory of what you have, at least yearly or every other year. And this is where advisors are really key as well. Confirm title and designations for all of their clients on the accounts that they're managing.
So I know that when Nicole and I were even prepping for this podcast, we were just looking, Googling about estate planning and just different terms that maybe we personally didn't really understand. And I'm sure a lot of other people wouldn't either. Mm-hmm. So can you give us more of a everyday explanation of the difference between a living will and an advance directive? Because we see those terms a lot.
Sure. So a living will is a type of advance directive. Basically, an advance directive is, this is what I want to happen in this situation. In terms of kind of the healthcare power of attorney area, which is where we're talking, you have the healthcare power of attorney, and that's the document that says, I want this person to be named. If I am incapacitated and unable to make healthcare decisions, I want this person to act. The living will, also sometimes referred to as the advance directive, is the document that says, if I am in a persistent vegetative state or I have a terminal condition and death is imminent, this is what I want to happen. So it's really laying out your wishes in certain circumstances about what you want to happen and kind of giving guidance to your agent that you've named about what they can and cannot do. And again, the document empowers them, but there are so many variables in the healthcare arena that I think having a conversation about what your end of life wishes really are is just as important as completing that document.
I am also wondering, after looking at the PowerPoint that you sent over to us, what the term laughing heir means.
Sure.
Some terms that are just like not things we use in our everyday language.
So in the estate planning world, what we refer to as a laughing heir is someone who inherits, typically through intestacy. So this is kind of one of the downfalls that we had talked about earlier. If there's someone who doesn't have a estate plan in place, the intestacy statutes will find your next living relative. In certain situations, that could be someone who has never met or didn't even know that the decedent existed. And all of a sudden they get a check for a certain sum of money, basically out of the blue. And so we call those—
Wouldn't that be a dream?
Because, yeah, so we call them laughing heirs because they literally start laughing typically when they receive this information. It's not very common, but it does happen. And it kind of illustrates the, I guess, application of intestacy and how it might not follow what your wishes are. Perhaps that individual would have wanted those assets to go to charity or to go to a friend or someone they actually knew, as opposed to running it through the statutes and having it go to someone they never met.
Yeah.
So I am curious to know too, like how often does, I guess I'm just wrapping my head around that. How does someone just decide to give money to someone they have no relationship with? I mean, like what kind of rationale would be there?
Well, they don't decide. They don't do planning, and the statutes decide for them. So it's not necessarily their intention, but because they didn't do any planning, the statutes will dictate who is their heir.
Makes sense. I guess I didn't realize that was only through when there isn't a plan. I just am thinking like some wealthy person is just choosing like a very distant relative across the ocean or something to send money to. And
I mean, some people in their planning, as kind of a last resort, will say, you know, if everyone that I've named in my plan, so children, grandchildren, other family members, if for some reason we are all gone, like we take a family trip or something happens, they'll say, well, I'll name my heirs. And so there might be a situation where that could happen in someone's documents too. Typically, I see it where there's not planning done. But some people will say, you know, kind of taker of last resort would be whoever my heirs are, because at that point, everyone I know is gone. So might as well leave it to whoever they can find at that point.
wow.
Man.
So we extrapolate pretty far in our documents to basically think of kind of all possible scenarios. And that is one of them. So we do say, if everyone's passed away, where do you want assets to go? And a lot of people will say heirs at that point, or charity. That's always a good pickup place for charities too.
What happens if somebody is the laughing heir and they get this check and it's this enormous like sum of money? Are they on the hook for all of the taxes for that? Or how does that work?
It depends on a lot of things in terms of how it was administered, what the terms of the trust would be, or, you know, if it's intestacy. I haven't had most people be upset with that because they got a giant check out of nowhere. So
It's like even if they had to pay a boatload of taxes, that's still a whole bunch of money that they weren't expecting in the first place. So
right.
about it.
Right. Yeah. So, you know, it doesn't happen often, but you hear stories from time to time in the news about someone inheriting from a great great aunt. And that's exactly the situation we're talking about.
Gosh. So, okay, speaking of taxes, let's talk about estate taxes. Why are they important? And then in the next 5 to 10 years, how do you see it changing? And why is that important to millennials?
So there's kind of two taxing systems in the US. There's the income tax, which most people are familiar with, and then there's the estate tax. The estate tax is taxed on assets that you own at your date of death. And so that's different than, say, the income tax that you're filing every year. There is a federal estate tax, and there are some state level estate taxes, but really the federal estate tax is what people are focused on. The exemption amount is the amount that you can have and not have a tax due on the assets that you have on your date of death. Currently, the exemption is upwards of $11 million per person. So you can have over $11 million when you pass and not owe an estate tax. That's assuming you haven't gifted anything during your lifetime that would affect your exemption amount. So that's a pretty high amount for someone to have. It doesn't affect a lot of people currently. That number, however, has fluctuated pretty significantly over the last 10, 15, 20 years. It is set to sunset at the end of 2025, and it will go back to pre-2018 levels, which is around 5 million. They index it for inflation, so they'll tell us exactly what that would be. The caveat is whoever is elected could totally change the tax structure as well. So it's very much a tax that has changed significantly and something to keep an eye on. It's been as low as under $1 million, and it's at some of its highest points right now. But it's important to know where you fall, because as you accumulate wealth and you kind of advance in your career and things like that, that tax is something you want to be aware of if it does go back down, because it will start to affect more people at that point.
And that's probably where it's important to be meeting with professionals like yourself or like a financial advisor to find strategies to all legally try to maybe reduce the amount of taxes that you'd have to pay, just as a responsible thing to do, both for yourself and for your heirs.
Mm-hmm. I think that a lot of people feel like that number is not sustainable. At a certain point, the justification for having that tax is not going to be able to be met because it applies to so few people. And so the reason they have it is to generate income for the government. And if it's not doing that, then there'll probably be a change at some point. So there's an opportunity now for people who want to do some really cool advanced planning that we can do. But it's certainly something to keep an eye on, because it will probably be changing at some point, either with a new administration or whenever it sunsets.
Is there a place someone can go? I mean, obviously Google, but if someone is trying to figure out what specific documents they need per their state, or is it really, you need the same documents for estate planning across the board?
You really need the same documents for estate planning across the board. So you're always going to need powers of attorney. You're always going to need some document, whether it's a will or a revocable trust, that says, this is where I want my assets to go. I'm hesitant to say Google it, because there's a lot of disinformation on Google about almost everything, but estate planning falls in that category as well. My biggest suggestion would be to talk to an attorney. And I know that's hard coming from an attorney to say that. But we see so much disinformation when we talk to clients about understanding how plans work, that I really think it's important to work with a professional who can explain in detail how all of these fit together and make sure that your plan is coordinated. It's certainly not a DIY type of thing to be doing. And the DIY plans that then I have to figure out after someone passes always are more work and a lot more complicated, because of the fact that, some of that was done without maybe an advisor helping. And the financial advisors play a big role in that too, in terms of, making sure that the clients understand, well, we are helping manage your assets, what we're doing is to make sure that you can pass some of this on to the next generation. And all of the work we're doing to accumulate wealth is going to be for naught if it's squandered in the transition because of some of these issues we've talked about.
And it goes back to what you mentioned earlier, which is that trying to do estate planning after the fact is so much more expensive than doing it beforehand and planning in advance. And I think a lot of people believe that estate planning is so expensive to do. And it may be an investment, but it's also so important to consider the pros versus the cons of not having one, and how much more money it could be costing either them or, their family members in the future if it's not done in a timely manner.
Absolutely. We see a lot of kind of the pros and cons just with planning, and then obviously administering other people's plans that they've done. And it is much more expensive and costly to do some of that on the back end. A, because you don't have someone you can ask about what they wanted, and B, there's stuff all over the place. You're dealing with family dynamics. And so, yes, it's an out-of-pocket cost on the front end, but it is so much more valuable to do it, while you're still living and you can have those conversations than it is after.
I just saw a video on LinkedIn, I think it was, talking about how Nicole, you may have seen it too. It was by Jamie Hopkins, who's pretty big in the financial services space, but he was talking about how a lot of people think, it's so important to save. And of course, saving is important, but sometimes it gets lost in the fact that spending is also important for happiness in a lot of ways. And money can actually be tied pretty directly to time and the value of time. So, some people may say, buying a $5 latte every day is silly, but for some people, having the 20 minutes of time where they saved by not making the latte at home is actually that valuable to them, to have 20 minutes versus the $5. And I think that ties back into what we're talking about here, which is if you don't invest maybe the money in the small amount of time now, you're going to spend more money and probably substantially more time after the fact trying to gather the documents and tie all the loose ends together. So it's like investing in, a retirement plan. It's tough to part with the money now, but it's so worth it and so necessary down the road. Mm-hmm. So I know we're getting to the end of our time here. We could go on forever, as we could with a lot of the podcasts that we do. But any last questions that you have, Nicole, top of mind?
I think we have this one written down. Just really quick, can you touch on what kind of advice you would give to millennials that need to start a conversation with their parents about creating or revisiting an estate plan, or just saying hey, is this something that you thought about? That can be an uncomfortable conversation to even bring up. I know my parents have gone to see their financial advisor, and they have stuff set in place, but I've told them all along, I don't want to know what's in it. I don't want to know what you have. But now I feel like I do need to know, for my own information, and for my brother, who is obviously going to be an heir as well, and just kind of see the structure. And I think I'm going to go with them the next time they have an appointment with their financial planner, just so I'm familiar with their, even the financial planner's process of, if something happens to one of them or both of them, how that even works. Cause that's going to, I don't even want to have to deal with that when that time comes. But what kind of questions would you encourage them to ask their family or their parents?
I think the biggest question is, do you have documents in place? That's the starting point, because if they don't have anything, and everything's going to be 10 times more complicated than it needs to be. And I guess one of the things I do want to point out is, we've talked a lot about what happens when someone dies, but I think it's just as important to talk about incapacity. Mm-hmm. A lot of our cases come to us because someone's still living, but they're incapacitated and they don't have the documents that they need to allow someone to act on their behalf in that area as well. So the first thing from my perspective is seeing what they have, and if they don't have anything, trying to connect them with someone who could help, whether that is you should talk to your advisor. Financial advisors have good connections with estate planning attorneys. They understand enough to be able to say, yes, this is something we need to talk about. The other thing is, millennials are doing their planning, and that's a good segue to say, hey, we got our documents in place and wanted to make sure that you had documents in place too, because we learned all of this when we went through the process, and we want to make sure that everything's in place. If something were to happen to you, now that we understand it from our perspective. So, if they have documents, that's great. But the first thing is to see where they even stand in that area.
Yeah, and I would even also add, asking where the documents are located. Because if you're not working with a financial advisor or an attorney, like, where do you have all of that written down? That's definitely a good question to ask as well.
Yeah, and we give the originals back to our clients and we keep copies, but it's up to them in terms of how they want to distribute any copies of those documents. The originals should be in a safe place, safety deposit box, safe in your house, whatever it may be. But a lot of clients are giving copies, particularly of powers of attorney, to their agents and their successor agents, because that's what they're going to need in case of an emergency. But yes, finding the documents after someone passes can be an issue as well, particularly if they're in a safe deposit box or you don't even know where they are. Safe deposit boxes, I would talk to your bank about what their policy is if you keep them there, in terms of being able for someone to access it after you pass, because there are some different policies per bank that has led to some issues, and even getting access to the documents.
So I'm kind of giggling over here because I'm watching this show, and I'm not going to name it because it's super girly, but it's a thing where like people can say like upon their death, like they will have papers like that, or like keys to a place like delivered to somebody. Like, is that something that somebody can set up?
I have never seen that. I guess you could at the bank see if they would do that. I guess the question is, who would you trust to do that? I don't know how legally binding that would be, but practically you could do something like that.
It was on a TV show, and I was like, I don't know if that's a thing, but I'm going to ask.
I am like thinking about all the times too where even husband and wives maybe don't know themselves, like between themselves, whether or not there are documents done. Like, traditionally the husband a lot of the time handles the financial stuff, and it's like, how many times does his own wife, maybe she knows that they have an estate plan, she helped create it, but doesn't know where the documents are, and it's something that's so small but can cause just, I'm sure, a world of headache down the road for people. So
and one of
these other somebody knows.
And one of the other things that's a huge issue now is everyone's online presence. A lot of information is now coming to people via email or other kind of electronic sources. And so while you used to be able to go through someone's mail and have a good idea of where they banked and where their assets were held, even between spouses, sometimes they don't have full access to all of that information, which is very much an emerging issue when someone passes. And the laws really haven't kept up with the technology in that regard about what happens to your online footprint after you pass away. And so, we have some provisions in our documents, but it's good to have a conversation so that everyone knows kind of where everything is. There is no magic place that you can go and find everyone's assets.
Very interesting. Yeah. And I think, even like, what is it? Facebook, you can name somebody as like to do your memorial page, even, having like social media handles, all of that information. Yeah. That's good advice.
Yeah. And think of your email. Bank statements come to email. Does your husband have your email password that if he needed to get in there and find that out, who has the passwords to what to get that information?
Right.
Kelly, thank you so much for
Yeah.
all of the great conversation and information you gave. I feel like we could keep talking for much longer and maybe could do a part 2 as well to dive into deeper topics as we hear maybe what questions we didn't answer from our audience this time that they're curious about. But really appreciate you taking the time out to join us. I think this has been awesome.
Yes.
Anything that we didn't ask that you'd like to make sure the audience knows, or just any little nuggets of information that we didn't touch on?
I don't think so. I mean, my biggest advice is just everyone needs planning. If there's one thing you take away from this podcast, it is to have those conversations. And even though it's not fun, cross this off kind of your life to-do list.
That's
Yes,
great.
absolutely.
Yes. So for our viewers, I guess, right, instead of just listeners, now we're having viewers because this is a video podcast. We will link our Face the Fear website and also our Face the Fear Gmail down in the comments section below. So if you do have questions about what we talked about, or for Kelly, send them our way. We'll make sure to pass them along and get any of the questions answered that you have. Also, don't forget to like and subscribe and keep following. We will hopefully have many more podcasts coming out here again soon. So thank you for watching and listening, and we will see you next time.
Thank you.
Thank you.